And we're very privileged to have Professor Ben Boer to give the first introductory lecture on an aspect of environmental law. And these lectures we are opening up to all members of the TTT, Environmental Law Champions Network, as well as being live streamed on YouTube, courtesy of the technical assistance of Angelo. So I'd very much like to introduce Professor Ben Boer, who is, amongst many things, I will read out a very short bio. He is a distinguished professor of law from the Thousand Talents Program expert of the People's Republic of China, the Research Institute of Environmental Law at Wuhan Daoshui University in China from 2011 until 2020. He was Professor of Environmental Law from 1992 to 2008 at the University of Sydney Law School, and he was appointed Emeritus Professor in 2009. He was Deputy Chair of the IUCN World Commission on Environmental Law for 2012 to 2016. He's a member of the Governor of Boards of the International Council on Environmental Law. He's a Fellow of the Australian Academy of Law. He's published a wide range of environmental and heritage law topics in books, articles, and reports. He's a founding co-editor of the Chinese Journal of Environmental Law. He has been always a strong supporter of environmental legal education and legal training in many countries. I think Indonesia was in 1992, perhaps even earlier. He is an extraordinary person who has made a fabulous contribution to environmental law. Although, as I think, as Christina Pack mentioned, for our distinguished Emeritus Professor here, Professor Kingley, he is also a very beautiful person. And it's with great pleasure that we invite Professor Ben Boer to give this first lecture on environmental law as part of this environmental law program. So thank you very much indeed, Ben.
Thank you very much, Matthew. I hope that everybody can hear me now.
Yes, we can.
Wonderful. So, Your Excellencies, Professors, ADB colleagues, and many, many friends that I see on screen. It's a great pleasure to address this curriculum development meeting in teaching environmental law in Myanmar. My congratulations to all of the team in putting this together, the ADB personnel, Matthew, of course, as well as all of the professors that have been involved in the last couple of years. It's hard to believe that it's some 2 years since we had the TTT program in Myanmar, and I'd have to say that I'm missing Myanmar. In the meantime, I'm very pleased to see that environmental law has already become a core subject in Myanmar's universities in 2019. And no doubt you are aware that only a few universities around the world have made this particular subject compulsory. And this is important in terms of Myanmar now leading the way. So my talk today is necessarily limited. I want to focus on just some of the major issues facing the region in environmental law, and perhaps indicate what we should now be teaching our students, and in particular also asking them to research what topics they should be researching in environmental law. Given my teaching philosophy about small group teaching, I'm sorry I cannot engage in small groups today, but I suppose that in a way we're doing that by being online together. In any case, I will try to canvass some of the topics that you now see on screen, sketching out some of the global and regional issues and so on. I will not have time to look at the basic principles of environmental law that I think should be fundamental to environmental law teaching and research, but along the way I might mention one or two. One of the things that I've been concerned about for, 30 or 40 years has been implementation of environmental law at a national level and in particular looking at how international law obligations and regional environmental law obligations play out at a national level. And my particular focus has been for many years on the ASEAN countries. Inevitably, since I'm a professor, I have to tell you that there are one or two things to read, and I'm very happy particularly to share with you the readings that I have on the screen, readings number 1 and number 2, the International Law in the Asia Pacific book, in which I've written the topic. The chapter International Environmental Law is one that I will be able to send to you, and you will be able to read it online. I've also written a couple of years ago an introduction to ASEAN regional environmental law, and some of you may have that already. One of the things that we need to think about in terms of international environmental law, though, is the actual developments that are taking place as we speak with regard to the negotiation of a global pact for the environment. And we already have a report from 2018, late 2018, in relation to the possibilities of having a holistic, legally binding agreement on the environment promoted by the United Nations. The fifth reading that I have there is a book that is just about to come out, which hopefully everybody will be able to access. You'll see some of the editors there are very familiar to you, Amanda Kennedy and Rob Fowler in particular. I've written a chapter of that book on small group teaching methods, and hopefully some of you will be able to use those methods as we did in the TTT program in 2018. As Matthew mentioned, I'm also the co-editor of the Chinese Journal of Environmental Law. That's now been going since 2017, and the reason why I flashed this up on the screen is because I would like you to write for the Chinese Journal of Environmental Law. It is not just about Chinese law, it is about environmental law around the world, so it's a very broad scope. But if you have something in particular about Myanmar that you would like to share, either in an article or in a recent development note, then please write to me, and we can then consider submissions to be published in one of the 2 issues that we do every year. I should say that the journal has a number of articles every time free online, and you can have a look at them on the Chinese Journal of Environmental Law website, which is very easy to access. Let us now just consider some of the major global and regional environmental issues that we face. Many of them have already been mentioned by 1 or 2 speakers in the video that we have just seen, but just to remind you, we're talking about pollution, we're talking about land degradation in particular, very important, particularly the Asia-Pacific region, the extraordinary loss of biodiversity, the diminishing problems to do with ozone depletion, the particular issues of climate change, which are increasing in scale every year and every day. And in particular, also, we see the loss throughout the Asia-Pacific region of natural and cultural resources, despite the World Heritage Convention, despite the machinations of the Intangible Heritage Convention. One of the things that I always try to remind my students of, and no doubt you've seen this slide from me before, but we need to understand that everything is interconnected. And that is the reason why the scope of environmental law is never ending. It's very large. One thing is connected to another, whether it's land degradation and climate change, or waste disposal, and the issue of planning human settlements and so on. So this is just a graphic which is very useful in terms of teaching and understanding the connections between the various environmental media with which we deal. Many of you already take a holistic view of the environment, and this is just one other way of putting it. We need to understand all of these issues and how they interconnect. One of the things that particularly exercises me, though, is that in the last 250 years, the world has changed very considerably in terms of its atmosphere, the composition of its atmosphere in terms of greenhouse gases on the one hand, as well as, on the other hand, the devastating loss of biodiversity around the world. And this is particularly the case in some developing countries where deforestation is taking place, where increased urbanization is taking place, where population is overtaking the rural lands, the forests, and so on, let alone the impact on the marine environment. So we are here at the moment. We're in the Anthropocene or human-centered age, where humans have had direct impacts on the natural environment, and that is not going to stop soon. But the task of environmental law is to try to stop it as soon as possible, to restore the environment, to restitute the environment as far as we can. When you look at the impact, for example, of energy use around the world, we see that we need to drastically reduce our energy, not just in terms of issues of climate change and increasing greenhouse gases, but also in terms of the simple idea of light pollution, as well as simple waste of electricity through lighting of the world unnecessarily. We also need to be aware of the way in which things are changing in the mountains and in the Arctic regions. And this is just a graphic which tells you a little bit about what has been happening in the last 200 or so years and what will happen in the next 50 to 100 years in terms of the loss of ice in the world's glaciers. So in other words, when we think about environmental law, we need to think about the scientific basis of that law. We need to be aware of planetary boundaries. And if we overstep them, what are the potential effects of that overstepping? And then what should law do about it? This particular diagram, which should be familiar to many of you, covers all of the major issues in terms of biosphere, in terms of fresh water, in terms of biochemical flows, in terms of acidification of the oceans, the issues of aerosol loading, and so on. So when we think about the scope of environmental law, this of course is central to your considerations in developing an environmental law curriculum. But it seems to me that this very broad curriculum, this very broad area of environmental law needs to be thought about at every level. Firstly, international level, that the international obligations and then the regional obligations that we also have need to be implemented at the national level. But you'll be familiar with all of these particular areas in terms of the terrestrial, the marine, the riverine and lacustrine environments, in terms of cultural and natural heritage, in terms of protecting and sustainably exploiting everything to do with natural resources. Climate change law is an obvious one. Energy law is increasingly important. One of the things that I would want to emphasize, though, is that we also need to focus on the area of environmental rights. It's becoming much more important now, and the United Nations Environment Programme is doing some extraordinary work as we speak in relation to focusing on the environmental rights of communities, of individuals, and in particular environmental defenders, those who defend the environment around the world. The last aspect there, trade, investment and environment, is also becoming increasingly important, and this is particularly so in countries in the Asia-Pacific region, where investment from foreign sources has become much more important, and that the effect of that investment on the environment needs to be considered closely, both by the investing country as well as, and in particular, the host country that is receiving the investment. As far as the definition of environment is concerned, it should incorporate all of these, the issues that I'm talking about here, but also let me emphasize, without going into it in detail, that the legal definition of environment is important in indicating the scope of your law. And as you know, typically in training courses such as the TTT, we use that as an exercise. What is the scope? What is the definition of the environment? It's important because a narrow definition indicates a narrow application of the law, and a broader definition, of course, allows judges and administrators to apply the law in a much broader fashion. We need to be aware of the effects of all of the human activities that we have been indulging in the last several hundred years in particular, and in particular now in this particular century. One thing that exercises me a great deal is the ocean environment and the impact, particularly on coral reefs, which are a major life source for huge numbers of aquatic life, particularly fish. But we also see the impact on the terrestrial environment of climate change. And these are the kinds of things that students really do need to understand properly in terms of the effects, both in terms of animals as well as on people. When we look at the situation in both the South and the North Pole, we see that the situation is changing drastically. We need to show our students that this is the case. We need to indicate both the limitations and the possibilities for the discussions around environmental law and what the environmental law can and cannot do. So one of the other aspects is to do with the marine environment, is the circulation conveyor belt, which we also need to be aware of in terms of the shallow and deep currents that are now starting to change very drastically. These are the kinds of scientific things that need also to be mentioned, albeit briefly, in environmental law courses. When we think about biodiversity loss, that's clearly something we need to teach about. We need to think about it in terms of the global policies that are being put forward. We need to think about it in terms of the analyses put forward by secretariats such as the Convention on Biological Diversity. One of the other things that we really need to be aware of, and this is particularly important in the Asia Pacific, where protected areas are being diminished or degraded unnecessarily by development, we need to be aware of what's happening in other parts of the world as well, in terms of environmental degradation and the loss of protected areas, and therefore the loss of biodiversity. So one of the other things that we really need to think through with our students and when we're researching are really, what are the underlying foundations of environmental law? What does society want from environmental law? And here I've put this out in terms of societal goals being fundamental to our environmental law, and that these should be implemented through principles and mechanisms set out in our law. One of the things that we need to think about and ask our students about is, what is the underlying goal? What are we trying to achieve in terms of the drafting and teaching of environmental law? What are the core principles involved to give appropriate guidance, both in terms of the design of environmental laws and in particular implementation of environmental laws through government and the courts? Principles are fundamental. Principles are very important. And this is why documents such as the Global Pact need to be looked at very seriously, and the drafting of the declaration that may come through in 2022 through the UN summit, the 50th anniversary of the Stockholm Convention, the Stockholm meeting, may well see such a declaration, perhaps a legally binding declaration, being produced, which incorporates all of the appropriate emerging principles. So we need to think about the norms of environmental law as well. In particular, thinking about both the rights of people as well as the duties of people. And this is where documents such as the Global Pact set that out. They talk about the right to a clean, healthy and sustainable environment on the one hand, but also the individual, the community and the state duty to look after the environment. One of the other issues that has become very important, as I've indicated, is that we need to take human rights approaches to environmental issues. And certainly every course that I now teach in environmental law has a segment of 1 or 2 hours on the environmental rights aspects of environmental law. That connection between environmental law and human rights is converging. It is becoming closer. And this is something we need to be aware of and teach our students about. Another aspect, though, that really needs to be understood and underlies a lot of this is the societal goal of sustainable development, or in some contexts, such as in Australia, ecologically sustainable development. And again, I don't need to go through this in any detail, but we do need to understand what the present needs are of this generation of people and of environmental aspects, as well as the needs of future generations. And so this question of intra-generational equity and intergenerational equity has become fundamental and important. The other principles that we talk about are also very important and need to be thought about. So we can see that environmental law has become a field of fundamental importance in the management of natural and cultural resources, as well as the protection of human and environmental health. We can see that this has become important particularly since 1970. But if you look at the last year, you see that connection between human health and environmental health has become even more important because of the effects of the coronavirus 2019, COVID-19, and this connection in terms of looking after the natural environment, ensuring that viruses stay more or less where they should be rather than escaping through vectors to infect humans, is something that we really now need to be concerned about as well. So certainly since the 1970s, there's been a growing awareness of all of these problems, which no doubt most of you are very aware of today. We need to start taking environmental law seriously. And certainly in Myanmar, in all of your universities, you are doing that. When we look at the situation in ASEAN, though, we see that there is a great deal of inconsistency between countries in terms of the national laws. We also see that there is not a sufficient regional approach, despite the strength of the organization of ASEAN, of the Association of Southeast Asian Countries, which has been around since 1967, but has not yet been able to put together an overarching agreement on environment for the Asia Pacific, or for the Asian region, notwithstanding the attempt in 1985 on the agreement on the conservation of natural resources and the environment. So you've mentioned some of the specific issues in the Asia Pacific region, but what I would want to say is that the issues of population and how to deal with population growth in terms of the growth of cities and the impact of that population on the natural environment is a very important one. But I would also want to say that the lack of a legally enforceable right to a clean, healthy and sustainable environment is something that really needs to be focused on more, even though we have the ASEAN Human Rights Declaration of 2012, and even though some of the countries in the ASEAN region do include a constitutional right to a clean and healthy environment. But even so, where those countries do have those rights incorporated into the Constitution or recognised through right-to-life provisions, such as in India and Pakistan. There still needs to be an emphasis on implementation, and this is where law schools can help. Law schools can do a great deal in terms of setting up clinical environmental programs to assist communities to implement and enforce the rights of communities and individuals. And this is where clinical legal aid has become very important over the years, becoming increasingly important in ASEAN. So whilst we see the development of regional environmental law, as I've indicated, the problems are to do with non-enforceability, and this focus on the ASEAN way is something that, well, I've critiqued for quite some time. I understand the issues relating to trying to enforce environmental law, but really it is time now to think through the kinds of ways in which ASEAN approaches these issues, because that influences the way in which environmental law is taught throughout the Asia and Pacific region, as well as in terms of how it's implemented. And Ko Keng Lian, for example, who was honoured in the conference yesterday that Matthew and the aerial team put together, the documents that she has put together are particularly important in understanding what the possibilities are as well as the limitations. So the challenge is how to solve or resolve the apparently inherent conflicts between the need to act collectively in the region, while on the other hand to maintain the principle of non-interference and respect for sovereignty. And this is where ASEAN nations, including Myanmar, need to start thinking very seriously about what their responsibilities are, both internally as well as to each other. So just to reiterate that we do have a draft 1985 ASEAN agreement on conservation of nature and natural resources, but only 3 of the original signatories have signed it and ratified it, and therefore it is not in force. The only hard law regime really that exists in ASEAN is the transboundary haze pollution regime, which has really only just started to be adequately implemented, with Indonesia finally ratifying in 2014. If we look at ASEAN national environmental law, we see that there is a great deal of inconsistency between one country and another in terms of approaches, in terms of the modernity of, or the old-fashioned nature of the environmental law that currently exists. This is a chart from that chapter of the book that I mentioned before, which I wrote back in 2015. You'll see that things have not changed very much in terms of the national scene in ASEAN. It's something that law students need to be aware of in terms not just of your own law, but of the regional law, and hopefully in the future we'll see that we have more ASEAN environmental lawyers, not just Myanmar lawyers or Indonesian environmental lawyers, but we have regional lawyers, people who can work in various countries in order to assist the development of and implementation of environmental law. And I assume that many of your students in Myanmar will see the point of working transnationally to assist countries in the region, etc. So what are the challenges in the next decade? Certainly, one of the things that we need to think about is the implementation of the 2015 Sustainable Development Goals. We need to become much more serious about implementing the Paris Agreement of 2015. We need to ensure a sustainable future for world biodiversity when we know that biodiversity is actually being degraded and going backwards. We need to expect and anticipate a new UN Declaration on the Environment similar to but stronger than the Rio Declaration on Environment. We need to see the reform of environmental law across the Asia Pacific at national level as well as at regional level. And the teaching of environmental law must be strengthened across the region. I'm very pleased to say that Myanmar is now leading the way, and my congratulations to you. Thank you.
Thank you very, very much indeed, Ben. And I'm wondering if you have some time for a few questions, if that's possible.
Certainly, no problem.
So can
Hi,
I...
Professors.
Yes.
Hi, professors.
Can perhaps you introduce yourself?
Yeah, hi,
Dr.
professors.
Malamo?
May I look at the slide 42, please? Yeah, slide 42, please.
Oh, slide 42, just a moment. Okay.
Yes.
This one here. Have you got some corrections for me?
Yes. Yes,
Good.
yeah. So for Myanmar national legislations, the forest law, you mentioned that forest law 1992,
Yes,
but forest
been
law
updated.
1992 is already repeat, and we have a new forest law in 2018.
Thank you. Thank you very much.
And then
yes,
again,
this chart is from 2015, I should say, but please go on.
Yes. And then we have a new law, Conservation of Biodiversity and Protected Areas Law in 2018. So we repealed the wildlife law.
Yes, I was aware of that as well, but thank you for pointing that out. And if I do a lecture on Myanmar law, I will certainly include both of those. So do not worry. Thank you.
Thank you. Yeah.
Thank you. And it's good that we have everyone is on board. So is there anyone who would like to ask a question? And I think also, Ben, you can click the English in the translation, because if anyone wants to ask a question in Myanmar language, we can also ensure that it is translated into English. But also,
yes.
As Hannah Lim has said, yes, regional lawyers are important. The environment has no state borders.
Yes, Professor Ben. Yes, I'm Ye.
Yes, hello, how are you?
Yes, fine, thanks. And I would like to support you to update the Myanmar law relating to environmental conservation. Yes. And today, I will send you the updated law relating to environmental conservation, because I have already collected. So,
good, thank you very much. I would very much like to see that. One of the reasons why that is because I am actually rewriting the book on international environmental law in the Asia Pacific, a book that was first published in 1998. So it's high time it was rewritten. And so I will incorporate the Myanmar developments in that book as well. Thank you.
Okay, I will send to you by tonight. Yes.
Excellent. Thank you.
Yeah.
And
any other questions?
Yes.
Can I ask? Yes. Yes, I'm Erie. Sorry. Sorry.
Oh, please, Do Win, and then we can so on.
Yes. I would like to ask, which country enact the climate change law? I would like to know. I forgot which slide you mentioned the climate change law. So I would like to know which country enact the climate change law.
Only a few countries have actually enacted specific climate change law, and from my memory, only one or two countries in the Asia Pacific region. But I would have to look at my notes to tell you exactly which ones. But certainly many more countries need to do that. There's one country in the Pacific that has done a small amount of change in its law, but in terms of having a holistic climate law, there are very few countries that have attempted that so far. But my view is that many countries should do so because the Paris Agreement would be much better implemented in terms of nationally determined contributions if countries did make much stronger laws relating to greenhouse gas emissions.
And perhaps, Dr. Edwin, if I can just put a website in the chat box for the AGNI, the Asian Judges Network. I do know that Fiji has a Climate Change Act, and also the United Kingdom has one. And the European Union has adopted their Green Deal, which is to deal not only with climate change, but biodiversity conservation, circular economy. But on the Asian Judges Network on the environment, there are now 4 volumes that have been prepared and that were launched. And volume 4 talks about the international framework and volume 3 talks about the climate legal and policy frameworks of 32 countries in Asia and the Pacific. And so that's on that Asian Judges Network on the environment.org, and that was supported by the work of Christina Pack and her team.
I just want to jump in, everyone, just on the climate change law. So right now, EDB's Office of the General Counsel, we're helping to support Fiji's climate change bill. So basically, it contains the operative provisions of the Paris Agreement. We just the government posted the second revised version in November. I'm happy to share the draft, and now we're doing interministerial and public consultations to produce the third draft, which we hope will be the version that will be submitted to Parliament. We're expecting in second quarter. I think the government of Fiji, they want to feature this law in COP26. Furthermore, we're also, we supported Lao. It's a climate change decree, not a law, but a climate change decree and a disaster risk management decree. So that's been adopted recently, so we could also share that. And now we're working to support the strategies, the climate change strategy and the disaster risk management strategies. And that's going to be finalized as well. Thank you.
Thank you very much, Christina.
I'm Professor Mickey Song from Ottawa University. I would like to discuss about the Myanmar law. Myanmar have enacted Myanmar Environmental Impact Assessment Procedure 2015 and Environmental Quality Standard 2016. And Myanmar had Myanmar Agenda 21, and the last 2 years, Myanmar enacted conservation for biodiversity and protected area laws 2018 and forest law 2018. So I think we have to we have to implement this law and rules effectively. Thank you.
Thank you.
Can I join one? Thank you, Professor Ben. Very interesting and very comprehensive presentation, and I have a lot of knowledge learning from your presentation.
Thank you.
Yet, in the opening session, the Myanmar, the related environment, particularly environmental legislation, was started in 2012. If we look comparatively at other countries, Myanmar is so young related environmental legislation and very limited scope, which is presently not practicing the Environment Conservation Law 2012. And after 2012, we understood the long-term policy framework is essential to be guiding how do we integrate environment into all sectors at different levels for the mainstreaming. So for that, we have developed several policy documents, framework, after 2012 until 2020 right now. And also incoming this year, later this year, some of the framework related green economy, related integrated natural resource to be coming. So the effective implementation of policy and framework, a comprehensive environmental law is a foundation effective to be you control the legally what's the issue happening related to environment and climate change, including, yes. So I'd like to know your experience. We are planning to review existing environmental law and relevant environmental related sector law to be developing more comprehensive environmental law as an umbrella, mother law. So for that, even at the time being only environment conservation law and rules. So how do we reflect it to be holistic, the framework for sector to be effective environmental compliance? So I learned from you. Thank you. Thank you.
Well, thank you. This is a big question, and it has several aspects to it. In terms of reforming environmental law, my experience dates back to the early 1990s when I worked in the Pacific Island countries and reviewed the environmental laws of 5 Pacific Island countries, and then following that in Vietnam and several other countries in the Caribbean. My experience indicates that what we need to do is to understand what the environmental problems are, number one, and number two, what the capacity of the administrative arms is in terms of implementing the environmental law that already exists, and then looking at how the current environmental law compares with other laws, some of the best laws, the best practice that you find around the world, and doing an effective comparison between one law and another. This question of comparativity, I think, is very important in terms of learning how good one's law is or how bad one's law is. So that comparative process is important. But another fundamental aspect of this is whether your law incorporates the emerging and established principles of environmental law, which are these days called the environmental rule of law. And one can elaborate on this in terms of the fundamental principles, such as the precautionary principle, putting that into law, principle of intergenerational equity, putting that into law, thinking about the principle of conservation of biodiversity. These are established principles in a number of countries, but also emerging principles such as the principle of what is called in dubio pro natura. In other words, placing a responsibility on environmental decision makers to make a decision if all other things are equal, placing a responsibility on decision makers to make those decisions in favor of the environment. This is a very interesting principle, in dubio pro natura, INDUBIO natura, which basically means if in doubt, decide for the environment. This makes a great deal of sense, both from the point of view of the environment as well as the point of view of people. But the final thing that I would want to say, Your Excellency, is this, that in reform of environmental law, it seems to me that we also need to ensure that we understand the societal goals of any particular country. I've mentioned that a little bit in my talk, but the basic goal in terms of what does the community want and what do individuals want can really only be perceived by ensuring adequate processes of public participation in the drafting of new law. And this is why some countries put together commissions of experts which hold hearings in communities to hear from what communities would want, number one, but number two, also to consult the experts. In this case, for example, the 30 or so universities in Myanmar that are already teaching and researching in environmental law use their expertise in order to review the laws. I cannot emphasize this enough in terms of using expertise that is currently already available to you. So participation of a broad range, ask the industrialists, ask the foresters, ask the communities, ask the academics, and also involve government officials who have to implement the law. They're the kinds of things that I would immediately think of in reviewing environmental law. Thank you.
Thank you so much. Thank you.
Good.
Thank you, sir. Is there any other question before we bring this first environmental law lecture to a close? And then we will, yes, Professor
there is a question.
Kimai, nice to meet you again.
Good to see you, Kenny. Yes.
Your lecture is quite good. And as you have mentioned, environmental law subject is too wide to focus one area, you see. So I'm considering about the appropriate items or syllabus for the fourth year LLB students. So if you are available, I would like to learn from you which topics are appropriate for the fourth year LLB students. If you have the if you are available, please provide us the syllabus of the law students of Sydney, University of Sydney and Wuhan University, please.
I can certainly do that. We don't have time to cover all of that now, obviously, but certainly I can send you some syllabi that I use. But what I would want to emphasize is that if you're talking about environmental law for Myanmar, that you cannot just include Myanmarese law. You have to look at the international obligations. You have to look at what regional obligations there are, and then also look at the Myanmar law. So in other words, you have to take a broad approach and then a narrow approach, and then come up with a satisfactory curriculum which makes students aware of the environmental, the human rights, the natural resources issues, and then to see how that plays out internationally, regionally, and nationally.
Thank you very much. Thank you very much.
We'll be in touch.
Jesu Timbade, thank you very much, Professor Ben. Can we?
Thank you. Good to see you all.
Thank you
see
very
you
much.
Again soon.
We also